Swayam Prabha. Digital India. Educated India.
Dear students, and today we are going to continue with our discussion on the last classes, and we were discussing about the horizontal restraints, and today we are going to discuss on vertical restraints and how the vertical restraints, and as in the last classes we discussed what is the vertical restraints and horizontal restraints, and horizontal restraints are on the same level of trade and vertical restraints are on different level of trade. For example, the distributor, the manufacturer, distributor, then retailer and chain on the same level of trade, and the one person try to control the entire system of supply chain. And in the vertical restraints, we are going to look into how the intellectual property is going to interact with or whether it is conflicting with the competition law in certain cases. So, especially with regard to the vertical price restraint, and so rarely happens when usually almost all the jurisprudence cases are on patents or trademarks or copyrights, and this particular the jurisprudence, the case came before the court is on trade secrets, and also the distributors or the manufacturer put contract restraints in the licensing agreements. To what extent these are conflicting with the competition law, and today we are going to discuss this in detail maybe on the last class of the first part of this course. And this is a very important case, it was important and now it is overruled, because Dr. Miles Medical Company versus John D. Park and Sons Company is decided in 1911. And this case set the jurisprudence for a long period of time, and almost you can see that it is overruled only in 2007. So, long period of time this was the jurisprudence set by the United States Supreme Court. In 2007, this decision, Dr. Miles' decision was overruled in league-in decision. So, our subject of discussion today is these two decisions and vertical restraints, how the intellectual property is interacting with the competition law, the Sherman Act in these through these two cases. And here the vertical restraints are basically on the contracts. The manufacturers always enter into contracts with wholesale merchants or retail merchants, and they try to control the prices from manufacturing to the wholesalers to the retailers and ultimately to the consumers, and they put restrictions on prices on all levels. So, what is the price of these particular products when the consumers available to the consumers? There is no choice for the wholesaler or the retailer to fix prices or to give some kind of leeway. It is entirely fixed by the manufacturers. So, the question raised in this particular case was whether this is amount to restraint of trade. If this is a restraint of trade, then it is definitely this violation of the Antitrust Act of 1890, and we will see very detail in this particular case. And here the complainant was a medical company, that is a Dr. Miles Medical Company in and Indiana Corporation, which is the manufacture and sale of proprietary medicines, and more importantly, and they are not holding any patents for these proprietary medicines, rather they have trade secret protection, which is again in the United States protected under legislations. So, it is a branch of intellectual property law which you see in our first classes, and which they kept it as a trade secret. All the formulas and product as well as the process are kept it as trade secret, and they have packages, labels, and they have trademarks. So, there is bundle of intellectual property is protecting these particular medicines from trade secrets to the packages and its labeling and also the trademarks. So, they have trade extensively throughout the United States, and these they sell they practice to sell the medicines to the jobbers, wholesalers, wholesale druggist and the retail druggist, and ultimately the medicines goes to the consumer. And all levels of trade the manufacturer fix the prices. So, here most importantly, when we look into the intellectual property protection, and definitely the trade secrets are protected under the intellectual property legislations. But the question is whether there is a correlation between the intellectual property protection and controlling the market forces. And the Dr. Miles says that this is a proprietary medicine and there are different intellectual properties are owned by me. So, I have a right to protect the prices in the market. So, here the rights are the trade secrets, the completely the processes are protected by the trade secrets. So, these processes, the intellectual property protection, whether it grants any kind of rights to fix the prices. So, the answer is controversial. So, we have to look into whether the intellectual property protection give the patent owner or the copyright owner or the trade secret owner absolute freedom to fix the prices totally at one level, at every level. So, so we will discuss this in detail. So, whether any point of time this is a restraint of trade. So, here the same medical company manufactures non-patented articles also, but there is no statutory right on fixed prices for future sales or restrictions to the purchases through a set of contracts. The manufacturer fixes the conditions through a set of contracts from wholesale to retail to the ultimately to the consumers. This is applicable not only in the case of the intellectual property protected medicines, but non-patented medicines as well. So, the question is with regard to whether these agreements ended between these people are unlawful. Our point of discussion is that these restrictive conditions which put in the agreements are violating any of the provisions of the Sherman Act. That is our question of discussion, whether it is the restraint of trade. Here agreements definitely there is an arrangement between the wholesalers, manufacturer, wholesalers and retailers through a set of agreements. So, the sole purpose is to control the entire market. So, again the question, and the manufacturer fixes the prices. The question is whether these practice are injurious to public, because if any kind of agreements which is restraint of trade or injurious to the public are void. So, if the public interest is hurt, this any kind of agreements are held to be void. So, and it no other legislations can save such kind of agreements. So, the argument is that this is only to enhance the prices or only to control the entire market. So, the Sherman Act very clearly says that the manufacturers along with the distributors agree for the prices, agree on, they fixes the prices. So, minimum the MSPs are fixed. The court in this particular case apply the per se rule which is there in section 1 of the Sherman Act and held these activities are illegal. So, the vertical agreements between the manufacturers, distributors and retailers and ultimately they reaching to the consumers, all the prices, the price fixing are held to be per se illegal. The court has taken a very tough stand and held that these kind of agreements are not going to benefit the consumers rather than going to benefit only the manufacturers, and so it is per se it is illegal. So, it was also further alleged that this purpose of protecting its trade, sales and business, this was one of the justification given by these Dr. Miles, which clearly says that it is to protect the sales and business and for conserving its goodwill and reputation. I am not able to understand how the reputation of a company is directly connected with the prices, fixing the prices. So, here and another argument was that all these are known to the defendants, through the agreement, and they are agreed earlier. They are part of this agreement, and the defendant in this particular case was cooperating with the plaintiff earlier, and they know the terms and conditions of this agreement. Then second was, this is very necessary to regulate and control the sales and marketing, all over sales and marketing of this company, to protect the interest of the company. And thirdly, the contracts are in writing, they required to be executed by all these the jobbers or the retailers or the wholesalers, and they know these terms and conditions, they know the terms and conditions of these particular agreements. This was one of the arguments. But the court looked into each and every argument, to every company to protect its trade and business, but not through exploiting the market, not through combinations, not through abuse of dominance, and every company to protect its goodwill and reputation, not by fixing prices. And thirdly, it is necessary to control the marketing. Yes, every company to control the market, but not by fixing the prices, and the prices should be determined by the market forces. And thirdly, every company imposes restrictions on its the wholesalers and retailers. So, this by the argument that the justification that the defendant knows the terms and conditions are not going to be sustainable. So, here this particular the wholesale drug business, the defendant, that is a Kentucky Corporation, the wholesale drug business, earlier they were into the business. So, they dealt with the complainant, they know, they have the full knowledge of the terms and conditions, and also they trade in medicines. So, this argument also is not going to be sustainable. They know the terms and conditions, because even though they know the terms and conditions, which is restraint of trade, is in violation of the Sherman Act. So, here know that it is in every pharmaceuticals, everybody knows that from the manufacturer to the consumer, there are a lot of chains in the supply chain, there are a lot of actors in the supply chain. So, here the defendant definitely the combination, and there was a combination and a conspiracy with regard to the wholesalers, retailers and jobbers in the case of proprietary medicines. The argument that even in the case of is proprietary medicines, the rights are limited, to the owner of the intellectual property. Once this intellectual property is going to exploit the market to violate any of the provisions of the competition law, the competition law will prevail over the intellectual property protection. And the Mr. Justice Hughes in this particular case has taken a very strong stand. So, he said that the complainant, the manufacturer of proprietary medicine, there is no doubt on proprietary medicine under protected under the legislations, and they prepare these particular medicines under the trade secret formulas, and it is protected under legislations, and they can fix certain prices, whether it is retail or wholesale, they can fix the prices. So, its purpose is to establish minimum prices at which sales shall be made by its vendees and by all subsequent purchasers who traffic in these medicines. So, the companies can fix prices to that extent, but can you put the conditions on restraint of trade? The answer is no. No manufacturer can put conditions in the agreement in restraint of trade. So, these restrictive agreement conditions are void. So, whether the consignment contracts or the retail contracts and the price fixing contracts. So, basically the retail agency contract. So, these the argument that even 25,000 retailers are all over the United States are not a justification to put unreasonable conditions. The conditions must satisfy the test of the Sherman Act section 1 and 2. If any kind of restraint of trade provisions are in violation of the Sherman Act. So, here the actionable wrong. So, we are not going to discuss elaborately on the actionable wrong committed by maliciously, the allegation by the Dr. Miles that the defendant has maliciously compelling other parties, other retailers and wholesalers to break the contract. That is not the question of our discussion. Our discussion is whether the intellectual property protection gives a complete freedom of the owner of the intellectual property to violate competition law. That is our question, but the answer is that intellectual property protection have a limited role when it comes to the market forces, and the moment you exceed the intellectual property rights in the name of intellectual property protection, you cannot do whatever you like to do in the market. For example, the patent law, the objective of the patent law is to stimulate innovation or to give an incentive to the innovator, but not to exploit the market. So, here there can be an exclusive manufacturer, but this exclusive manufacturer adopts unfair means and refuse to deal. Then yesterday the last class which we discussed, the essential facilities doctrine will come into play. So, the competition law to take care of the market or competitive process has to continue in the market, so that there will be welfare in the market. And then again, so if the public is not going to be yield any benefit, but only concerned about they are not going to get any kind of benefits because of the practices of the company, and definitely it is going to be attract the provisions of the Sherman Act. And these restrictive practices, so whether a condition in the contract is a restrictive practice or not, we are going to look in from the purview of intellectual property as well as the competition law. And there can be an exclusive agreement according to the intellectual property law, because you have a monopoly for a limited period of time, but that does not mean that you refuse to deal. So, the refuse to deal, that is to be dealt under the competition law, and competition law will come into play, and they will look into the details of why you refuse, whether you are charging enormous royalties, whether you are fixing the prices, whether you are going to be making cartels. So, all these ingredients to be checked under the competition law. And if you look into, so Dr. Miles, it is very clear, the court has, remember this particular case was in 111, and the court decided absolutely applied the doctrine. So, very clearly applied the doctrine, that per se rule, and they said we are not even going to look into the other doctrine, this opposite doctrine. So, accordingly, so 2007 case, the next case we will look into the next part, we will look into the second case. According to the new case in 2007, the Department of Justice and the Federal Trade Commission has issued new guidelines by looking into the new jurisprudence. So, issued the new guidelines in 2017, and which says accepted these particular principles, and the first principle says that the agencies apply the same antitrust analysis to conduct involving intellectual property as to conduct involving other forms of property, taking into account the specific characteristics of a particular property right. So, they have to consider definitely what kind of intellectual property protection is available, to what extent it is available to the owner. But at the same time, the antitrust agencies do not presume that intellectual property creates market power. So, they change their philosophy of looking into the competition issue, because the Dr. Miles was overruled in Ligon case. So, we are going to see that particular case. Thirdly, the agencies recognize that intellectual property licensing allows firms to combine complementary factors or production. Yesterday we talked about the complementary technologies and supplementary technologies, and the agencies will consider it as pro competitive. So, the per se rule is not going to be applicable. So, the rule of reason is going to be applied in this 2017 the cases. So, the shift is happened. So, we talked about how the Dr. Miles, very clear, the court said that the per se rule will be applicable. Per se, these fixing vertical agreements are per se illegal. But in 2007, another case came before the Supreme Court of the United States, that is the League in Creative Leather Products INC versus PS case INC 2007 case. Almost similar circumstances, similar facts. In League in, the court reconsidered the case in Dr. Miles, whether the resale price maintenance, whether the resale price maintenance is per se illegal, evaluated, and this question was evaluated. If you apply the Dr. Miles principle, then you need not to reevaluate. So, blankly you can say that if you apply Dr. Miles, so resale price maintenance is per se illegal. But this case, in this particular case, the court again look into and evaluated very thoroughly whether it is per se illegal, resale price maintenance are illegal at the vertical level, whether it is have a anti competitive effect or pro competitive effect. So, this we will discuss this particular case. Thank you.